Welcome to this edition of this week's The Link. And the promise we are trying to keep, bringing you information you can use. Whenever you come here, be assured that you will find things that are practical, things you can use in your life, in your business, to make decisions. Tonight we're talking about something that is premised on what is out there in the media, questions of patenting and intellectual property. And my guest tonight is Mr. Paul Assimwe. He's an advocate and he works with CP Law Associates, and they have a specialty in intellectual property beside other issues concerning trade in terms of law. Counsel, you're welcome.
Thank you very much, Mr. Ssettumba. We're delighted to be on the link once more.
Very well. Let's start with the issue. Innovations, we have seen innovations of late in the areas of medicine, and they are causing friction and acrimony when things look good. So let's ask the question. Uganda is on an innovation trajectory in many areas. So what kind of legal problems can spring up when people in groups or with institutions and individuals innovate and things start looking good?
Thank you very much, Mr. Ssettumba. It would be ideal that when innovators are collaborating, or where you have an innovator employed in a company or in an institution, you have a clear framework that governs the relationships. Now, in many cases, you would have employment agreements saying that so-and-so has been employed to do A, B, C, and D. Unfortunately, in Uganda, because we haven't had a very strong history of innovation, sometimes innovations or inventions or creations of the mind, like copyright works, are not properly spelled out. And so increasingly, the gap that may exist that we seem to see as legal practitioners is the absence of institutional policies. And what are institutional IP policies? Institutional IP policies basically spell out what happens when this employee develops a new application. It could be some kind of software, it could be a product, it could be a process. All of these are things which would be ideally protected using the patent system. Now, in the absence of that policy, what the law says, the Industrial Property Act basically essentially says the innovation will belong to the institution. And it's basically what you would call a statutory assignment, even though in cases where the employment agreement is silent, then the default setting would be that the institution will own the innovation. So in order to avoid these kinds of things, even where you have in private businesses, where you have the likelihood of new and creative things coming up, it would be important that the company actually has an IP policy which clarifies who will own the IP, or there could be some form of benefit sharing where the employer and the employee share within the percentages set out in the policy.
So, Counsel, can I, if I'm innovating with an institution, with a company, for instance, if there's no policy, can I ask for those things before? Moreover, what is common is that I innovate within their premises, they have their own infrastructure, they have their own buildings, and that's why I innovate. And at the end, they own it. Can I ask? How can I?
No. The position is this, that if you create something within the working hours of the employer, whatever you develop clearly belongs to the employer, okay? The clear exceptions would be that whatever has been created is beyond the remit of your employment, okay? So let us say that you're a scientist, okay? You're a software developer, okay? And outside your working hours, you come up with a medicinal application, okay? Because that is not within the normal remit of your work, it cannot be claimed by the employer. okay? But if it is within the ambit of your employment contract, then clearly the employer is going to claim it, and the law actually supports that. So the important thing now is that before you are employed, or if you feel that you're the kind of person who has the propensity to come up with new things, it would be important that your employment agreement is clear and it spells out what would happen if you came up with something inventive or something that could be protected by IP.
Okay, moving on to innovations and patents. Give us an idea here. What is patentable and what can't I patent?
Okay, so our law, the Industrial Property Act, permits a person who has created something that is new. The law calls it novel. Novel means something that is new, something that is inventive, so something that someone who is an expert in the area would look at and say, no, this thing was not there before. So for instance, in Uganda, and I'm just limiting it to Uganda, at the time that Professor Msazi came up with his sanitary pads from, I think, from papyrus, there was no one else who had an innovation of that nature. So if you limited novelty to Uganda, it would be deemed that Professor Msazi had actually done what? Come up with a patentable what? Innovation. And then the last test is that it should be industrially applicable. It should not be something that is just theoretical. It should be something that society can benefit from, that can be mass produced and is useful. So that is the kind of thing that would be patented. Now, patent essentially means something that has been given a certificate and is exclusively given to the person who has applied for the patent. I would just maybe compare it, for instance, to a lease. So when the government, if you are into farming and you wanted to grow maize, for instance, and maize is a very critical need in the country, the government, you can apply, for instance, for a lease, okay, on a 10-acre piece of land. Now, the government, if you apply and the government feels that you meet the criteria, the government can give you a lease of 20 years, okay? So that certificate that you get, the lease certificate, is very similar to a patent certificate. In the case of patents, they will give you a certificate for 20 years, which means if Mr. Ssettumba gets a certificate, okay, a patent certificate, he can prevent everybody else, businesses and individuals, from doing what the law has allowed him to do. So the law gives you an exclusive monopoly for that period. So in this case, if we're talking about the example of the lease, the government gives you the exclusive right to grow maize on that 10 acres of land. Now, when the 20 years expire of the lease, then your rights obviously are terminated. So it is very similar. That's the similar example that I would give. The only exception in patents is that if you do not use that patent for 4 years, a third party, someone else can come and say, no, this person was given a right to grow maize on this land. This is the 4th year, they have not utilized the land. Please, government of Uganda, can you give me the right to grow maize? Because people actually want what? Maize. So that is the exception, and the exception is actually called a compulsory license. That would be the way that I would describe a patent right.
Okay, Council, in about one minute and a half, advisory. Now we have dealt with individuals and institutions, but we are friends and we are innovating and we are going to succeed. How do we avoid the minefield of acrimony or friction? What should we do? We are friends, we are in a group. What's your advice?
Yeah, it is important. It's important that you do a few things. One is that you need to do an inventory of IP, or the intellectual property. One may have come in with a very, very unique logo, okay? That is IP that he's bringing. Another one may have an algorithm, okay, or a software that they have brought that is a form of IP. It could be protected by copyright, but it could also be protected by the law of patents. So when you agree on what you have come together with, then you will agree on how you want to share that IP. So it is important that you identify the IP, and then if it is not registered, go ahead and register it. And then thirdly, if you're going to deal with other people, you need to sign some form of non-disclosure agreement so that they do not disclose, for instance, the secret behind the invention to your detriment. So those are the key things that I would mention. But I wanted to point out one quick thing on the things that are not patentable in Uganda. So things which are obvious, things like photosynthesis in a plant would not be patentable. You cannot patent a plant, you cannot patent an animal. But one of the other things that are not patentable in Uganda for now are pharmaceuticals. And this is very important for universities like the University of Gulu, which has come up with something, which I think is a situation under our law that we need to rectify, because until 2033, Uganda and other least developed countries are obliged not to protect patents on pharmaceuticals. And this is presumed to help the reduction in drug prices. But the flip side is, while it was intended to prevent people like the Pfizer's, companies like the Pfizer's from patenting, you will find that it will affect a university like Gulu or another university. So we need to find a balance in which the minister in charge, for instance, the Minister of Health, is able to come and regulate the drug pricing, but also allow innovators to go ahead and patent. So I feel that there are safeguards within the law which should allow us to go ahead and encourage the patenting of pharmaceutical inventions, which will encourage investment in this area, rather than put a blanket ban on the patenting of medicines and related inventions.
Thank you very much, Counsel Paul Assimwe of CP Law Associates and an expert in intellectual property. For viewers, we promised you that we bring you things you can use. I hope that was useful. As usual, we cannot explore the whole limit, and I'm sure you are burning, you're wondering why we finish now. I'll keep on asking for more time, and they'll give it to me perhaps eventually, so that we get all the information. That was the link. Thank you for joining us tonight.